Me mo bi akwaba eba Melodies TV so. Say during the week me the story Ebremo last week me the story Ebremo say the full judgment on MPP Vincent Eko Asefwa a call Supreme Court say Chief Justice process di removing no Supreme Court embongu no me the judges mienu de Ebremo me the His Lordship Unikulendi edie by Emma Ghana for comment here. Me sanso de Her Lordship Mensa Bunsu Her Lordship Bunsu ati ase me de ono so ne de by me hu se mu nia mo comment. But there are other judges in so ewo ho a say ewo se me de no so ba other judges or more judgments ewo se me de no so ba because you see the matter is still in Supreme Court. Okay. So far, Supreme Court about 3 or 4. And okay, so far the Rebecca said technically no. Ekwasefwa no ya boegu. And the other one in so sa ekubi no de call ya wo mulusu 4-1 no. And no judgment enya ye den embaye. But the Chief Justice herself, the suspended Chief Justice herself no, and so edene de akọ. And it is basically the same arguments. And so I feel say if we are able to know the judges or more judgments on the previous ones now, basically no, you can even predict this one no, based on the panel. And the acting Chief Justice in so no, I think say that will be his own. That will also be the cross he is going to bear. Because once we know, it's more like the same cases. And so once we know the judgment from the judges and their thinking, you'd want to believe that Chief Justice Abano, and also it will be that, because the cases are really not different. I hope you understand what I'm saying. So it is good that we see what the judges are saying on this particular case. It is very, very good. Say you heard the judges not adding eka. Into no way, ruling now, it was 3-2. In favor of against the petitioners or the plaintiff, into 3-2 in favor of the defendants in the person of the Attorney General. Now, Yenkai the Judge Amadou Tanko JSC into where judges are not case nisono NS Gau Kulendi Professor Mensa Bonsu and Amadou Tanko and then Bafo Boni into ye ready a year Judge Kulendi dear, you ready Professor Mensa Bonsu and so dear, aka a year NS Gao dear no some mo pese me deba or no so na or say Chief Justice Nyansanson Fanembra. Say NS Gao dear no mo pese me deba in the comments box no, you know what to do. Mon type 1. Or type 1 our comment box no more. I'll do a review of NS Gao's judgment. And so now let's look at a year Judge Amadou Tanko. The judgments are or no so edeba. Let's see the reasoning no. The entire or ma ruling say Dabi president the warrior no Mrama ne kwan say was warrior. So he started by giving the background, okay? So Amadou Tanko o judgment now how the omunina eshase and say omoshase with the background of the case. Send your case ne ba court and the reliefs are a year plaintiff or mudi case ne ba no the reliefs they are seeking. That is the person or the back court or say yenye den yenye mano. Now let's look at the application. Also, in this application, the plaintiff praised the court for 2 reliefs formulated as follows. It will say, an order restraining any step or action from being taken as part of the processes for the removal of the Chief Justice under Article 146 or in any manner, and an order suspending the operation of the warrants or suspension of the Chief Justice issued by the President under Article 146(10) of the Constitution 1992 until the hearing and final determination of the instant action. Enti judge ne trese ensem mienu a Vincent Ekwasefwa a Gofredami edi nenim eba court no ensem mienu omo de bae no say yema order Supreme Court ne ma order na processes na His Excellency John Dramani Mahama washa asia wodi remove Chief Justice no yembo processes no engu. 2 Supreme Court emma order na the suspension of the Chief Justice no yensan so manembra ni yenka se until say ye be di case ni wie no His Excellency John Dramani Mahama will need to me be so bad then or suspend the Chief Justice. No. Now I say, as deposed, 2 in paragraph 7 of the affidavit in support of the application, the pith and substance of the plaintiff's suit before the court on the back of which the plaintiff invokes the discretion of the court for injunction relief is that the consultations initiated by the President with the Council of State to determine whether a prima facie case is disclosed in the 3 petitions against the Chief Justice when the Chief Justice had not been notified of the petitions was a flagrant violation of the Constitution and renders the whole process under Article 146 null and void and of no effect. It was a ejinaswa ekwasefwa ene gofredame ede ba court no. Says 2 reliefs ya midin kan no. Si ye mbongu no. Eni ejinaswa wo mudi jinaso ene se. Emra His Excellency John Dramani Mahama osha ase ene Council of State for say womu determine the prima facie case e won sem ni mu no. His Excellency John Dramani Mahama amma Chief Justice no when notifying of the petition inti enu hunti the whole process His Excellency John Dramani Mahama was ase ne ye mongu na tre say Mahama nye process ni ye inti omunjina so pa wo mo de ba court no inti Judge Amadou Tanko nsem oka o say the clear import of the above deposition is that the plaintiff takes the view that the President initiated consultations with the Council of State to determine whether a prima facie case is disclosed in the 3 petitions against the Chief Justice without notifying the Chief Justice of the petitions. The veracity of otherwise of this position will be interrogated shortly in this ruling. Into a say, the clear assem MPP for case no or no judge no wa bebe asem ni mu because asem de ba e wo se wo ba ba mu na emu dwo na wo hu bebi e wo se wo de to nti wa ba asem ni mu e ma we hu ne se MPP fo gi na so Vincent Asefo MPP MP no ni gi na so ano no ni gi na so a wo de kasa asem ni ye mbongu won ka say Mahama won yusu mbra because they can't say Article 146 no Mahama when yusu ni ye dabi. They can't say Mahama the removal of the Chief Justice no. Mahama sebe emra mane kwan dabi. Into anu di ohune say ekwasefo na sem ankasa. Ene say embra Mahama share processes na se no. Wambo Chief Justice na mane. Na nke o say Mahama bona mane. Into say wa share process na se na wambo Chief Justice amane dia. Maye Mahama nto aso. Into no judge ne de ohune say asem no ejina so a ekwasefo ade aba no. But to see, sansem na ekwasefo ade aba no. Se eye nokware, enye nokware, or no judge no obetretre mu. Into where I was say the veracity of otherwise, or say the veracity or otherwise of this position will be interrogated shortly in this ruling. Into say asem ye nokware, eye jina so pa, se enye jina so papa no, or no judge no, or no, obe baba asem ni mu. Na wo bia ye den atiase nti Judge Amadou Tanko the work no. Now I say in support of his case for injunction, it has been deposed in paragraphs 8 to 16 of the affidavit in support of the application that the whole process for the removal of the Chief Justice is contrived. It's a contrived scheme plotted by the President and the National Democratic Congress government to remove the Chief Justice from office. This scheme, the plaintiff contends, had been hatched even before the NDC government came into office. The deposition in paragraph 16 of the affidavit is in support of the application is set out as follows: that I am advised by counsel and verily believe same to be true that the Article 146 proceedings initiated against Chief Justice so far are a ruse to give effect to the avowed determination of the current government to unconstitutionally remove the Chief Justice from office. Into a say, MPP for the assembly eba court no. Our mube siki injunction. Say Chief Justice ma yen yi no. Dear wo de bebe support you mo ho ene say NDC 4 time kra no mo ye campaign no. Na His Excellency John Dramani Mahama ene NDC 4 account to say omo be yi Chief Justice na free so. Enti se wan ba na chief justice no ye yina na tre say eye pobonia NDC for boy enti no MPP for evidence a omode court say yen seek injunction ne mom no no ekwase for evidence or the koye no enti judge ne nsem a work no as the merits of the application okay enti nsem a mode aba beto anim ni me bia mu mehu ne say nsem no ni ni okay afa yen hwe application na wode aba no ene ehu ne say o udi bem ne ehu ne say daabi dia udi be inti judge no be treatim or say it is now tried that in the area of public law where this dispute belongs, one of the first principles that the court considers in the exercise of its discretion with regard to injunction application is that the applicant must show that there is a serious question to be tried. See the case of Welford Kweku versus Attorney General and another 2012 1 SCGLR 259 at page 260. The Welford Kweku case was applied by this court in the subsequent cases of Ransford France number 1 versus Electoral Commission and Attorney General 2012 at page 692 and Indabugri number 1 versus Attorney General Aka Ese and Chemu Power Co Limited number 1 213 to 214 2 SCGRR 1 JLR 1134. Now basically no asemwa judge no can say baby ababedu no ye kan Ghana mra baby asem na ababedu no yes ye Ghana mra de na Ghana mre mu no se obi esiki injunction wa asem bi so a court no first thing I want her and say ade a wo ba be siki injunction e wo so no ye pese ye bisa ana ye hwem se asem no a was serious question to be tried ana on say me mamoti say o court na o koje injunction en sorry keke enkon koje injunction ya na asem a ye kan say ye bisa say is there a case of ebia unlawfulness be a AC. I mean a perfect example, right? A perfect example. Even say uni obi ewo asase ho manso. Asase ho manso bi koso. Right? Iti even say asase ho manso bi uni obi wa asase ho manso bi, right? Ena mo akọ court. Na mo court no, we hu ne say nipa kro no o si dan ewo asase ne so. Eno betumi akọ court akọ injunction say ben nipa kro no on to aso so be si dan no and to say mo be wie case no because wo si dan no he is or she is really affecting the land. What you say o see a permanent structure on that land inti no say illegal process be koso so that one the court can come in and seek an injunction inti no person address say answer na court ebema injunction no e wo see ehu ne say ade bi na koso na ya ade bi aye ntumi reverse no boni bi aye ntumi reverse na atiase inti basically no no now went on to quote in Welford Kweku and Attorney General and another Supra Dr. Dateba JSC as reported in page 260 of the report articulated the position of the law as follows. And you see all the judges no ohia omo judge ye ni na no omo ekoti Dr. Dateba the ruling na odema in this case. What you see? And I mean when we were reading Unikulendi no onunso ekoti Dr. Dateba and onunso quote this same thing. Eka say it has always been an understanding that the requirements for the grant of interlocutory injunctions are first that the applicant must establish that there is a serious question to be tried. You see, just as I explained. Okay, so we've dealt with that again. Now another case I want to also odi in Fatuhun in Ransford France number 1 versus Electoral Commission and Attorney General Supra. Answer JSC of blessed memory quoted the dictum of Dr. Dateba above and concluded as reported into to me who said say injunction case bia quarter one case awomu kosipa Dr. Dateba. What Dr. Dateba said on injunction say how or when and there was a wobabe seeking for injunction because I know omo ye so that there will be standard And so be able sorry sakeke so oko akwa siki for injunction. What you say? Into no judges ni na ya no mo koti Dr. Dateba. Now, because I say in light of the authorities cited, the first question that must be determined in this application is whether the plaintiff has demonstrated from the affidavit in support of the application that there is a serious question to be tried in this suit having regard to the allegations of which the application is founded. To answer the question, I first interrogate the key facts on the back of which the application before the court is made. As aforesaid, this is deposed to in paragraph 7 of the affidavit in support of the application which I produce as follows. Inti sisiano ye pese ye hu asem ni mu na de kware no. Injunction na mo be siki no. Ye mbisa ye ho se injunction na mo pese musiki no asem ne ya asem bi a esefata se wo se ye ma injunction na because they've given the rules through Dr. Dateba cases e wo se ye ma injunction. Inti ende ye be hwe okay case we qualify into here Amadu Tankwa ne de no me be say case we qualify say ye be man injunction na as simple as that. What you say? It was say that the trust of the instant action is that the consultations initiated by the president with the Council of State to determine whether a prima facie case is disclosed in the 3 petitions against the Chief Justice when the Chief Justice had not been notified of the petition was in flagrant violation of the Constitution and renders the whole process under Article 146 now void and of no effect. Also, the plaintiff thus contends in paragraph 7 of his affidavit in support of the application that the upshot of this case is that the president initiated consultations with the Council of State to determine whether a prima facie case is disclosed in the 3 petitions against the Chief Justice without first notifying the Chief Justice of the petitions. This contention has been is premised on the provision in Article 1466 of the 1992 Constitution, which provides as follows. Into a tremu say, wo MPP for eko asefo a wodi case na ba no. Asemo a wo kan say, His Excellency John Dramani Mahama on the Council of State for atena said ye, on your mo afine prima facie case there. But wo asem ne say, one ma Chief Justice no, one bon nkae MPP for wasem no. Iti judge asemo a wo kan say, okay. Say one kasa wa admit it. Say president no, any Council of State for any kasa na ke ko ban say president no, on one take a decision without consulting the Council of State. Because we tiamra. But say one kasa wa admit say one the Council of State for etenase. And of final prima facie case there. Then yankwa Article 1466. Edian Article 146 eka. 1466 no eka. And I say, and minim say at least for this month, we will be able to follow my platform where me sure Article 1466 ni there. And there yes so yenyane wa no pakra na obetumi ekoti because we've gone through it. Into say Article 1466 no, where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the President, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. It is noted that the provision was interpreted by this court in the case of A.J. Chum and Attorney General and Akwete 2005-2006, SCGLR 732. In that case, Dr. Dateba JSC held that the requirement that petitions for the removal of justices of Superior Court must first be filtered through the prima facie test clearly stated in Article 1463 of the Constitution must be read into the provisions of Article 1466 in respect of petitions for the removal of the Chief Justice as well, even though Article 1466 does not so specifically such that petitions for the removal of Chief Justice must also first cement the prima facie test. It what tie judge na asem a woka. We say Article 1466 no, asem a woka ne say ye pese ye Chief Justice na. Yes, yenye de Mahama ye no. But over Article 1466 na nkasa kra na, eno kra no, wanka say uyi Chief Justice na yen find prima facie case. But you see in Ghana, if Supreme Court Emma ruling na, it more like becomes a law. And na enye Supreme Court pe courts Emma ruling it's more like becomes a law. Interna say lawyers at the case court no omu koti say oh based on this case. So here judges ne krana omu koti judgment. Say based on this case course in 2005 judgment judge we ma ye no enu hunti yen so ye de no sa pepepe nti moma the same judgment. What you say? Inti lawyers nso use judges nso use. Inti judge na say ma work can say in 2005 to 2006, case because between Obi Efeno Eje Chum any attorney general. Na that time no judge and not case ne so that ban. Asema waka ne say yes, ukwa article 146 in the removal of the chief justice na. One can pose yen find the prima facie case against the chief justice. But on no judge ne dia ka ho say that chi bi ye ba be chief justice I was say ye find the prima facie case. Inti judge ne nsɛm a wɔka no Judge Amadou Tanko ne nsɛm a wɔka no Nti say be that as it may, to support his case that the president initiated consultation with the Council of State to determine whether a prima facie case is disclosed in the 3 petitions against the Chief Justice without first notifying the Chief Justice of the petitions. The plaintiffs' release on Exhibits B and C attached to this affidavit it's in support of the application. Indubitably, Exhibit B is a letter from Office of the President dated 28 March 2025. In the first paragraph of the letter, the President informs the Chief Justice of his receipt of the petitions. In paragraph 2 of Exhibit B, it is conveyed as follows. As the following receipt of these petitions on 24th of March 2025, His Excellency wrote to the Chairman of Council of State forwarding the petitions and informing Council of State in accordance with consultation process required under Article 146. He intends as an initial step to send the petitions to you, the Chief Justice, for your preliminary comments or response. Into I say evidence a dom wenim exhibit B your friend Exhibit B. Now Exhibit B no letter B the Office of the President, His Excellency John Dramani Mahama, Troye. Eka say Mahama receive petition. Na petition na His Excellency we receive no on the Council of State for tenase. Ewo petition no eso. Na Mahama kra no wa forward the petition no ama Chief Justice no for her response. It was clearly, therefore, Exhibit B admits of no ambiguity at all. It is Exhibit B na ye letter na e free His Excellency John Dramani Mahama ne office no. E tremwa Mahama ndi bone because case awode ba ne say Mahama ashe process na se no ama Chief Justice ante. But Exhibit B ye letter ne tre say well obo Chief Justice na manie. So you see what I like about Judge Amadou Tanko ne say he is going extremely technical with the thing. Okay, case number. These are the guidelines that you did the case be say. Guidelines that you did the case be any. Let us take it through and see. It's where he's taking it. He's not doing anything emotional. Oh mama, yes, and they were a judge. And then ye younger say young judge. And yet nas in the air say bibi says sidabi. He's taking it through. Okay, in some modiabani. Into munjina suni. Okay, evidence nini. Into me as a judge, no, may share evidence na hemo asemo amodia ba. Enko. That is what Judge Amadou Tanko is doing. Or see, Exhibit B actually assures the Chief Justice that her comments and responses to the petitions will be sought before the prima facie determination is made. So letter na His Excellency John Dramani Mahama etroye no. Letter no etrem kra say. Yebe say yete wo ne kransana prima facie case na yeden aba. It is a munia mobekaya. Embra ekwasefo adwane court. I letter babon to say Mahama krano watro ama Chief Justice say. Chief Justice find the response embra no. Asemo amekan ne say ekwasefo case no sisia no aye mut munia moka asemo amekan no. Say sisia case na dani foolish case. And so the judge na asemo awoka no. Say say wo back court na beka say Chief Justice nyambo na mania. Exhibit B ewo ho etre say letter e babontin ye bo Chief Justice na manie ye mane kwan say won responde ye ka kire ne kra say ye bema wa responde mpo ansa na ya hwe see ye benya prima facie tia wa na ye nya ntia wo. Until the judge is breaking it down for Ghanaians to understand. Or say the president therefore caused to be categorically conveyed in Exhibit B that his information to the Council of State on the petitions includes a direct communication to the Council of State that he intends as an initial step to send the petitions to you. Inti we bie mu tre Mahama letter ne kra say Mahama letter no in a paragraph no. Brofo wo use ne say the president intends as an initial step. Now, brofo ye ka say bibi initial and not say ade edi kan. Inti not say president ne kra throw on the letter ni mu say de edi kan a meye and say me send the petition no amaw ansa na me decide bibia on it. It is a president akasa tre chief justice no. Now why ya? MP before then na mudi ababe gina ye ni mu amoka say president de why no ti amra. Embra be no ti a. Mo say one fa de na ma chief justice ansa na will decide. Meanwhile in the letter which is evidence in court, it shows that brofo will use to yen say initial step. Not just so ye kran ansa na prima facie eba. I know I like this judgment. I like how this judge broke it down. Judge Amadou Tanko. I like how he broke it down. Or say there is thus no need to waste any judicial time on the meaning of the word initial. As I was saying. It was say or no judge, no. All man may pray. All man may wasting the time and be tre in a word I friend initial emu. Yen in ayete brofo. Obi ka se bibi initial address adi edi kan. Ati asiye di edi kan no ne brofo ene friend initial di edi kan. Inti se Mahama ka se initial ne se initial step ne se me de ma wo chief justice. And actually say di edi kan ne se wo chief justice wo na obete. Into by wasting the time and treacherous abro from the enye English class and all. It is clearly and simple. It clearly and simply means that before any other thing is done in respect the petitions, before any other thing is done in respect the petitions, the first thing the president has decided to do is to have the Chief Justice provide her comments and responses to the allegations contained in the petition before any consultation with the Council of State can proceed to determine the question of whether a prima facie case has been made by the petitions. To say clearly, Edaho say answer na Mahama be take decision no. Or my Chief Justice ne respond ye. Or my nekwan se won tre na adwen e wasem no. Clearly, exhibit B no. That is what it shows. It is therefore factually incorrect, as the plaintiff puts out that the initial consultations between the President and Council of State was to determine whether a prima facie case is disclosed in 3 petitions against the Chief Justice. In this Mahama ne Council of State for Kokotinase ebe prima facie case and sign a Chief Justice ebe bona mania. Clearly the evidence doesn't show a evidence game and a play a quarter. In Exhibit B, it is clearly communicated to the Chief Justice that her comments and responses were the first matter to be considered before the President and the Council of State will evaluate the petitions to determine whether the petitioners had met the prima facie threshold. I say in Mahama letter no, my Chief Justice say, wo comments no, ye bete no, and no, any ye din kind, ebenya ansa na ye decided on a prima facie. President my Chief Justice asked them say. For this reason, it is also inaccurate that the President initiated consultation with the Council of State to determine a prima facie case without first notifying the Chief Justice of the petitions. In the MPP for the Abba say, Mahama dinkan ye process na ansa na wobo Chief Justice amane. But say letter we any evidence a eda hono, it clearly shows. Brofo Mahama yusu ye na ya ko school. Bibia tre say when my Chief Justice no responde ye ansana or more final prima facie. This is interesting. Also, it is also apparent from Exhibit B that there is no question whatsoever that the Chief Justice was not only to be notified of the petition before the prima facie determination will be made, but her comments and responses to the petitions were to be first sought before such determination. Before doing so, however, the President had acted in compliance with the provisions of Article 1466 of the Constitution of the Constitution to first inform the Council of State as clearly stated in Exhibit B, after which the petitions will be referred to the Chief Justice for her comments and responses prior to the prima facie determination process. Into I say, idea His Excellency John Dramani Mahama ye no. O read the constitution na ye ni na yet yasiye. Article 1466 no. And no pepe because Article 1466 as more kind say Mahama wonding kind number Chief Justice amanie. Only kind number Council of State amanie. But obo mo amanie a no any council take a decision answer. Inti clearly no say Mahama edin kind po in any case. Yemfa say odin kind po no bo Council of State amanie ansana or the letter name Chief Justice ne na wonye boni because Article 146 no the catcher ne say wonye no odin mraso. Just as I've always been telling you, say adia His Excellency John Dramani Mahama eye no mra and obi biara why na adwen say obe dili adia no with emotions no or no beka say ne Mahama we but oya wadwen say wo de mbra no just like Judge Amadou Tanko why na clearly you see say he's making a lot of sense. And this is devoid of emotion. He might personally be having his personal relationship with the Chief Justice. But the law is being the law here. I say, as conveyed in Exhibit B, the communication on behalf of the President states in paragraph 3, therefore, thus, on 27th March 2025, His Excellency received responses from the Chairman of the Council of State concerning to this request. Copies of these letters are also attached. The initial communication with the Council of State, therefore, was simply to inform the Council of State of the receipt of the pending petitions and no more. There is nothing in Exhibit B which directly or indirectly suggests that the President's communication to the Council of State was the beginning of the prima facie determination process. As noted in Exhibit B, the reactions to the initial information from the Minister of Communications at the Presidency, Exhibit C, was needlessly and completely hysterical. The facts deposed, 2 in paragraph 7 of the affidavit in support of the application before the court, which oxygenates this application and the entire suit, is undoubtedly asphyxiated by the clear words of Exhibit B. Jajama du tanko brofo. Hey. Until he went on to quote another case that happened in 2015-2016 between Owusu, Abrante BFN Owusu, and Ado. What I say, that case, it also dealt with an application for stay of execution because they were also requesting say stay of execution. Yema Mahama enjoy the war, what you say. And I work say, I find the principle laid down in that case by the Chief Justice at the time, Georgina Wood, or Wood CJ, relevant and applicable to all applications. Until that time, 2015-2016, now the Chief Justice, Madam Georgina Wood. Now that time the case BC between Owusu and Ado. Na ye kosiki stay stay of execution. But that time no Georgina Wood Emma ruling bia wonu nu hu say ruling no it affects this case kra. Ruling be na Georgina Wood Emma yentie. In that case, the learned Chief Justice held that applications are predicated on facts deposed to in the accompanying affidavits and annexes. If any, in like manner, challenges to such applications are by parity made through the factual depositions contained in opposing affidavits, including annexes if any. Consequently, a challenge to any of the material facts on either side of the legal divide triggers the full panoply of the evidentiary rules related to the burden of proof. Thus, if a party challenges a material fact as deposed to, and the party on whom the burden of persuasion lies fails to discharge the legal burden, that fact may properly be classified as an unproven fact and cannot ground a grant or refusal of the application as the case may be. See pages 1492-93 of the report. And I like this quote very much. Or try say, Chief Justice Georgina Wood, 2015-2016, no case be by na case nearby na someone wa kind say, oh, Ye de court, ye judges any ha. Case na beba ye nim no. Material na evidence a modi ababeto ye nim. Se wo ka se obi ye na ejuma. Inti court emma stay of execution. Manipa krono, maye mani nye na ejuma. Wa wo siki se nipa krono ma wo nye na ejuma no. Une wo se wo de evidence no ba betre. Di enti eni kwansi ye manipa krono onye na ejuma. Enya se eno ane se wa ba court. Sa court nipa ko wo ye ejuma nanso for stay of execution to ne so me mani nye ejuma no. Ne ye sorry ya ye si okay dia wo kan tre evidence papa fatu ye nim. The burden of proof na da wo so say material na da ye nim no wo the evidence no ebe tre ye ne ye hu enye emotions inti tre ye evidence e tre say no hu nti man nipa ko ne nye na ejuma nti ono de case we ba ye no wo hwa gofredame ene ne asefua omontumi antre evidence papa bi e tre say no hu nti yen stop his excellency John Dramani Mahama from his constitutionally mandated duty omontumi antre evidence omutumi tre evidence dey anko no de be yasem. In the instant case, the crucial fact upon which the application is mounted has not only been denied, but has been demonstrated to be contradicted by the very proof Exhibit B on which the plaintiff relies to make out his case. Case amokra mo de abano. De mo kakra no, aside the fact say enye sanet no Exhibit B ne kra tre say de mo de abakra no enye say bia His Excellency John Dramani Mahama waye boni bi. Insemo amode bakra no Exhibit B evidence a ababeto ye nim ne kra no e tre say mo kra asemo amode ba ne kra no e contradicted de mo ka. Mo say wa ma ne kwan na so Exhibit B ne tre say o ma ne kwan brofo a wo use initial step na tre say wo din kan ma ne kwan po. Ti de mo de ababeto ye nim exhibit ne kra no evidence ne kra no ene mo asem ne kra nko. As the key fact on which the application is based has been shown to be mere perception, there can be no serious question arising to be tried from obviously inaccurate assertion, which has been vehemently denied by the defendant, Attorney General, in paragraph 4 of the affidavit in opposition to the application. Apart from the fact that the application is premised on facts which do not bear out the case for an injunctive relief, the defendant, Attorney General, opposed the application by an affidavit in opposition dated 2nd of May 2025. The defendant, Attorney General, referred to Exhibit AG3 attached to the affidavit in opposition. This affidavit reveals that the Chief Justice personally requested the President for her comments to the petitions, a request which the President had obliged per Exhibit AG2 attached to the affidavit in opposition. Into what I said, Chief Justice Nekrano, or no crash President, they say President no money, intie in sem no one responded. Emma President no, F1 so. It is all bana o de ababa see him say President no, or share process na se no wama Chief Justice antia say wama or answer ne be find the prima facie no, wama Chief Justice no, en ankasa wo ho en no koko take decision no mo find prima facie. Evidence scratcher say Chief Justice the crash key any the man no. And what are you saying? And to say, having acknowledged these developments, it is difficult to appreciate how the plaintiff seeks an interlocutory injunction to grant. I say, and you see, it is something I've always said. Or say, having acknowledged these developments, it is difficult to appreciate how the plaintiff seeks an interlocutory injunction to truncate a constitutional process by seeking a discretionary remedy on grounds which the party directly affected by the alleged default on the part of the President has on the evidence compromised or waived, even if the facts on which the application is based were well founded. Inti ono Judge Amadou Tanko fact we ni na babetu nenim wahwehwe nsem ni mu ebiebia asem ni mu edi bebia wo se nokware eto edi ato no won hu die nti a gofredame ene ne asefua mo aba court no won ka so bema mo injunction say constitution na ama President His Excellency John Dramani Mahama ejuma se wonye a wo ye na ejuma no mo ntumi antre bibia etre se won ma mo sign injunction no Nadia Mahama war, it was a constitutional process. God bless Judge Amadou Tanko. And you see, this is what Ghanaians are seeking for. What you say? Mbrana ba. Bibia was said that no yamfanto. What you say? I say, in my view, the plaintiff's counsel's argument does not sit well with the position explained by the court in Welfare Kweku case. The case makes it clear that the test applies to constitutional matters as in the instant case. It is also obvious that the plaintiff's counsel's response to the submission made by the Deputy Attorney General that the plaintiff's counsel did not find this point answerable because the plaintiff did not show what damage he will suffer if the application is refused. The application, therefore, demonstrably fails this second test as well. Now, I didn't read point 31. Let me read point 31 because without the point 31, 32 doesn't really make sense. Right? I'll say, it is on this point that the second principle in the Welford Kweku case becomes relevant and applicable. The second test is that the applicant must demonstrate that he will suffer irreparable damage which cannot be compensable, by the award of damages unless the interlocutory injunction is granted. In a reply to the Deputy Attorney General's submission to the effect that the plaintiff has failed to demonstrate the damage he will suffer if the application is not granted, plaintiff's counsel replied that the contention applies only to human rights matters. Now, I say, answer the Ebema injunction in sono. Another thing, and they say, I was saying when they say, Adiana air cosono, just as I said, a dear bia, a best say, Bibi Emma, yen to me yenny ye cra. Inti a assassin also no, obi more co assassin home, and at the second party, wababe to two form a seed dying or your foundation. So one go see King Junction no see a dining we are. A bear den so be assassin as it was. Into another dear, a bear cause irreparable damage to the land. The state of the land will be changed. Tianono dear was a dear you see King Junction. Utumi prove ya a bema injunction. Or see case where about Tohono. Godfrey Damia or your lawyer no. Yeah, can't say. Okay. Prove it check court no. Says idea we are because we have Chief Justice process now. And you say be at this process no, ebe cause irreparable damage to the Chief Justice. Because at the end of the day, see you kohune say wondi bonebiana, ye better so manaba as a Chief Justice. Inti prove it saying, say processes where more prayer, more person more stopping or no. What irreparable damage is it going to cause to the Chief Justice? If she goes through the whole process and then undi bonea, is she not going to come back as a Chief Justice? Inti Godfrey Dame prove it saying irreparable damage ben Godfrey Dame sorry ya when to me and try asem a walk a human right asem but Godfrey Dame was not able to prove any point when to me answer into here and until no point 32 say in my view the plaintiff's counsel argument does not sit well with the position explained by this court in the Welfare Kweku case. The case makes it clear that the test applies to constitutional matters as in the instant case. Inti Godfrey Dame human rights in some way can jai kra asem we a constitutional law and human rights laws a constitution. It is also obvious from the plaintiff's counsel's response to the submission made by the Deputy Attorney General that the plaintiff's counsel did not find this point answerable because the plaintiff did not show what damage he will suffer. In that time, no, Attorney General on the side and Deputy Attorney General, Justice Shrem side, judges ne say, also bisa Godfrey Dame question say, irreparable damage being and the cause Chief Justice Godfrey Dame want to me answer. Emma afi wo to papa so no can human right. The reason why Godfrey Dame was not able to answer and they say onim e wona kumemu said there is no way dear way ebe cause any irreparable damage to the Chief Justice if at the end of the day Yehuni say wondi bone bia she's going to come back as a Chief Justice. Inti or say sa response na Justice Remsai e kan ye no of what so say indeed that is why Godfrey Dame was not able to prove in court. So he goes on finally or say I deal with the third test formulated in the Wilford Kweku case. The point made for the plaintiff is that the alleged default by the president, which has been shown to be factually incorrect, is one which potentially renders the entire process of the removal of the Chief Justice a nullity. It has been held in a plethora of cases that where the grant of the final declaratory relief will nullify the acts complained about, the grant of an order of interlocutory injunction is inappropriate regardless of the intermediate steps that may have been undertaken during the pendency of substantive proceedings. Into asemo what can I say? Say kokoba ne say His Excellency John Dramani Mahama krano. Say be process ne krano. Wan shasi ya. And interest process ni na no yembongu. What the you can say? The judge na asemo say ni more kano ane and Mahama the ye nti no not to say process no according to the constitution wan shasi ye nti no and no yembongu. O say that be so the ye kofa ne say process ne kra Mahama shasi ye say ni anka also shasi na wan shasi sa. And the kran tre say yembo ni nsem ni nengu. And the kran tre say process no yembo ni nengu. Intino went on to quote another case and order. So this is the ruling from Judge Amadou Tanko at Yasie. And so he went on, but basically, the most important one I also would say and not Enamediabrel, but he went on to quote other cases to explain his point well. At Yasie, because they say Abwane de Ukuna na we kuna prequintino obubo case bebre at the church and insem emu. Now I want to read his conclusion. Okay, into only Judge Amadou Tanko. Okay, so it was Judge Amadou Tanko and Bafuboni, right? Judge Amadou Tanko and Bafuboni. That's quite interesting. So that means they all really shared the same thoughts on this, or because I'm seeing Amadou Tanko Edin Ewo. So this is Judge Amadou Tanko. This is his thoughts on the whole process, and I think we all understand Judge Amadou Tanko and the decision he made, but I'm not seeing the conclusion. I want to read the conclusion so we see. Maybe did he give any conclusion? Subsequently, the application, in my view, devoid of any merit to justify a favorable consideration, it's accordingly dismissed. Okay, so basically, that's that. That's the conclusion. Judge Amadou Tanko, straight. One chair or then 72 baby was ordered so as we expect judges to do. Ati I say, why you need Juma? Yankupon Shano. Montreal, your comment box, Medase.